Hello, everyone. My name is Neel Chatterjee. I'm a partner in an American law firm named Goodwin Proctor, and I'm an intellectual property litigator. Today, we're going to be talking about mediation in IP disputes. And this topic is near and dear to my heart whenever I come to India, because my grandfather was a clerk of the High Court in Kolkata. And about 15 years ago, I started going to India to work with Laila, who's here on our panel today, to help start developing mediation systems in India and in conjunction with the high court systems throughout India. And the programs that I played a small role in helping develop have become enormously successful in India. And I feel very privileged every time I come back, and I feel like I'm honoring my grandfather whenever I do so. So thank you all for allowing me to come today. Today we have three very, very distinguished panelists. I'm going to start with Laila Ollapally, who practiced in the High Court of Karnataka and the Supreme Court of India for nearly 30 years. And then in 2007, when I met Laila, she was invited by the Chief Justice of Karnataka to serve as the founding coordinator of the Bangalore Mediation Center. At that point in time, there were just a few mediators that were being appointed to work in the Bangalore court system. But with Laila's leadership, it became really the national standard by which the court-assisted mediation programs have been developed. She has mediated several hundred cases. She's been nominated to the International Who's Who of Commercial Mediation and serves as a panel member of the Singapore International Mediation Center, as well as several others. She spends a considerable time training judges, lawyers, and advocates on mediation and negotiation. And she has actually founded a private mediation center in India today called CAMP, and she serves as its lead mediator. But CAMP also has a number of other mediators. So welcome, Laila. I'm glad you're here.
Thank you.
For me, the most important thing is I also feel very privileged to call her my friend. The next person I'd like to introduce is Jeff KICHAVEN. Jeff is also a good friend of mine, and he is ranked in Chambers as one of the top mediators in the United States. Who's Who Legal lists him as a global thought leader in mediation, and it's only one of 25 people in the world that have that title. He's been a full-time mediator for about 25 years, and he specializes in intellectual property cases. And having worked with him myself, I really have to say he's one of the best mediators I've worked. He's an honors graduate of Harvard Law School and a Phi Beta Kappa graduate of University of California, Berkeley. He's been to India twice to judge mediation competitions and address the judges and mediators in the Delhi High Court. He loves India. He actually, if you look at his picture, you can see he has some elephants behind him, which he collects from India, and he can't wait to visit again. Welcome, Jeff.
Thank you, Neel.
The final person I'd like to introduce is Bijal Vakil. Bijal is one of the best known intellectual property lawyers in the United States today. And he works at White & Case in its global intellectual property group. Bijal has a very strong track record of litigating complex patents in district courts, the International Trade Commission, and before the Federal Circuit, which is the appellate court for patent disputes. He's ranked as one of the world's leading patent professionals and IP strategists, and he's also ranked in Chambers USA as a leading patent litigator. Bijal also maintains a very close relationship with the judges in the Northern District of California. And for those of you who aren't familiar with the Northern District of California, that is the court system that is for Silicon Valley. And Bijal is really one of the preeminent Silicon Valley IP litigators. And the judges invest a lot of confidence in him by having him serve on a number of their key committees. And he's also a trained mediator through the Northern District of California program. If, in case you're wondering how great Bijal is, he represents companies with household names such as Hewlett-Packard, LG, and Google. And once again, I feel privileged to call him my good friend. Welcome, Bijal.
Thank you, Neel. It's an honor to be here with all of you.
So one other thing I'll mention about Bijal, Bijal travels to India extensively to also talk about IP disputes, and he has a number of Indian clients. I think with those introductions, I'm going to turn to talking about some of our topics for today. Jeff, I'd like to start with you. Now, a lot of people here may not be entirely familiar with mediation. They might have heard it as a concept. They might have heard things like conciliation and arbitration. Can you perhaps explain what mediation is and how it works?
Sure, Neil. Thank you. I'm happy to talk about what mediation is and how it works. A mediation is a negotiation. It's a negotiation in which a third party neutral, the mediator, is involved, managing, supervising, participating. It's a series of managed conversations. The mediator manages the sequence and the timing and the participants in different conversations, all with the goal in mind of helping clients make better decisions with the advice and counsel of their lawyers every step of the way. The goal of mediation is for clients to be able to make clear, strong decisions, calm, informed decisions, better decisions than they could have made at the beginning of the mediation day. Almost always, people will decide to settle their cases. We sometimes say that a good settlement makes people equally unhappy. I don't believe that. I don't believe the purpose of mediation is to make people unhappy at all. I believe that people should settle cases if and only if the settlement leaves them better off than they were before, better off than they would be without the settlement. And in that regard, they should be happy. Now, it's true that in the typical distributive negotiation, plaintiffs generally get less than they think they should get, and defendants generally pay more than they think they should have to pay. But the financial dimension of the settlement is only one of its dimensions. There are other dimensions. People get finality. They eliminate risk. Clients are able to get back to their families, their careers, and their lives. And if the benefit of those other dimensions outweighs the disappointment that people may feel with the financial term, that is when cases should settle. Mediation is not about bullying. It's not about coercion. It's not about forcing people to do what the mediator thinks they should. The mediator creates the environment in which lawyers and their clients can do the best work they've ever done of negotiating, coming up with new ideas, picking among them, and if all works well, settling their case.
So, Jeff, I had a couple follow-up questions about that. When people are involved in litigation, they often expect that what they're really looking for is a decision from a judge. So is it the role of a mediator to say who's right and who's wrong?
A mediator can share evaluative input, Neil. In fact, we're all human, and it's very difficult for us not to share our evaluations of the case. But there's a distinction. I often tell people I'm not a fortune teller. No mediator is a fortune teller. We cannot predict with absolute certainty who is going to win and who is going to lose, because sometimes the long shot comes in, and people are sometimes very surprised by what judges and juries do. Although we are not fortune tellers, we are odds makers. And we do help people understand the risks that they're taking. Sometimes the balance of emotion and reason is not right, Neil. Sometimes emotion is too intense and reason is not playing enough of a role. And what mediators do by staying calm, by asking questions, by directing the conversation, we help logic, reason, and emotion come into a better balance. And when those factors, those different parts of your brain are working in harmony, that's when people make better decisions. Do you sometimes have to smack somebody on the side of the head and tell them there's just no way in the world that this is ever going to fly? Well, yes, sometimes you do. It's a rare circumstance. In those cases, it's generally when a lawyer has been trying to get the same bad news through to their client unsuccessfully. And when mediators are most effective is when we are supporting lawyers in improving communication between lawyers and their own clients. If a mediator is trying to use force to convince a lawyer-client team that they are just wrong, that's a very steep uphill climb. Because in the eyes of the client, if there's an argument between a mediator and a lawyer, the client knows, the client will instinctively believe their lawyer, the one with the duty of undivided loyalty, rather than the mediator, the person who at some level or another just wants to see a deal get done. So mediators have to make sure that they're working in concert and in harmony with lawyers if the mission is to help clients get emotion and reason more into balance so that they can make better decisions.
And I have one final question for you, and then I'm going to ask Bijal a question, and then following that, I'm going to turn to Laila. What about the issue of confidentiality? Because a lot of people sometimes worry, if I say things in this mediation thing, will the judges find out about it?
Confidentiality can mean many things, Neel, and in some senses it may be more important than others. One sense of confidentiality is evidentiary confidentiality. Can what we say here today be introduced in evidence at a trial or become subject to discovery? There's evidentiary confidentiality. There's what we call caucus confidentiality. If the mediator is having private caucuses with people, will the mediator keep secret or be at liberty to talk to the other side of the lawsuit about what is told to them in caucus? And then there's what I call societal confidentiality. Can you talk to a newspaper reporter? Can you talk to your neighbors or other people in the community? Those are at least three different aspects of confidentiality. And before going into a mediation, it's the responsibility of the lawyer to make sure that there is an agreement on the types and degrees of confidentiality that serve their clients best. It may not always be the same in every case. It's the responsibility of the lawyer to monitor that.
Bijal, I'm going to turn it over to you. And you represent some Indian companies. How do you explain how mediation works to them, and what kind of resistance do you face, and how do you deal with that?
Yeah, thank you, Neel. It's interesting because the lens that I bring to that question of how to explain to an Indian company that mediation is going to be useful in resolving a dispute, I try to bring my background, right? I bring my background as an IP litigator here in Silicon Valley, and I also bring my background as a mediator for the court. And as Jeff correctly pointed out, one of the main issues, number one, is confidentiality and whether the two litigants are comfortable and okay with the confidentiality provisions. As Jeff mentioned, those can quickly be resolved if the parties trust the process. And so that's very important to establish that trust early on. The main problem that I find with Indian companies is that they are concerned that the process won't be fair. For some reason, they believe that going to court in a very prolonged battle is both more fair than this negotiated business solution, and also allows them the chance to have a bit of publicity in the court that's really called social media these days. And trying to get over those two hurdles, in my experience, is the hardest, right? Trying to explain that the process is fair and that it's okay to have a process that won't be reported on Twitter or Facebook or anything else, because at the end of the day, what you want to resolve is the underlying dispute and have both parties go back to business. I remind them, in the United States, 99.9%, as you well know, Neel, of these IP cases resolve themselves with some sort of business solution. And so reminding them that their efforts are better suited towards business and not playing lawyer, like the role that I'm supposed to do, typically helps move the process along.
Just to add to that, Bijal, one thing that this concept of fairness comes up a lot, particularly with international clients, not just Indian ones. And one of the things that I often tell clients is I say, when a decision comes back from a judge or a jury, the maximum number of people who will feel like they were treated fairly is one. One person, the winner, might feel like they were treated fairly, or both people will feel like they lost, or one person will feel like they lost and the decision was unfair. So when people get hung up on this concept of fairness, the reality is walking into a courtroom, you have a 50% chance that you may still feel like you were treated unfairly at the end.
That is well taken position, Neel. You're absolutely right.
Laila, let me turn it over to you. You've worked closely with American mediators when you were first being trained, but now you have well over a decade of experience on the Indian style of mediation. What are the differences between the two, and what have been kind of the obstacles that you've had to overcome in developing mediation in India?
Yes, I did spend time with some great American mediators, and Coming back to India, I think essentially when mediation is about connecting to the parties, it's similar. We try to do the same thing. We connect to the parties. But the way we connect, maybe in India, because we are the high context culture, it's a different approach. So possibly that's one area of difference. How we connect. In India, we have respect, safe, saving face. These are concepts that we give more importance to while we connect. Another difference I felt is maybe it goes back to what Bijal said, the familiarity with mediation. They come with a mindset of kind of maybe like arbitration. They really don't know what mediation is. So we spend a lot of time helping them really understand what mediation is. And at camp, we do it at different layers. The business person does it, and the case manager does it, I do it. We are frequently helping the parties to understand what is mediation. And this whole concern about is it fair, is it not fair, also stems from that slight unawareness of what exactly mediation is. Once parties go through mediation, once they've experienced it, they realize this is self-determination. There isn't really fairness, is not such a big thing. They decide only if they want to have that solution, if they think it's the best thing for them. So essentially, these are the kind of differences that I may have noticed in the Indian scene, Indian mediation scene.
So, Laila, I'm going to have a couple follow-up questions about this. When you were in the Bangalore Mediation Center, just generally, do you know about how many cases have been mediated there now?
That's 200,000, yes.
Wow. Congratulations, Laila. That is quite an impressive number, much more than I would have thought.
Well, wait till you hear this, Bijal. What's the success rate on resolving cases in mediation in the Bangalore Center?
At the Bangalore Center, this is a court annex program. So we have a panel consists of about 60, 70 mediators. The success rate is about 65%. And at our mediation center, the private mediation center, it's more than 80%.
That's wonderful news.
And I wanted to, before we get to the IP specific things, Laila, what are the majority of the cases that you see in the Bangalore Mediation Center?
At the Bangalore Mediation Center, the majority of cases are matrimonial. There are different reasons for that. One, the law prescribed a concept called conciliation. Now, this has been going on for many years. So, in the matrimonial courts, they are familiar with conciliation, which is a process that didn't work for the matrimonial disputes. So, as a matter of habit, they started referring the conciliation, the judges started referring the conciliation cases for mediation. And when they saw the success for mediation in the mediation process, they continued to send more and more cases. And now I think 80% of the matrimonial disputes are mediated, and more than 70% of them resolved. So mediation is now considered to be a success for matrimonial disputes. Of course, we are struggling with expanding that, the feeling of success to other kinds of cases. It's taking a little more time. But in the commercial, in our private mediation at camp, we do all kinds of cases. Matrimonial is only one part of it, very small part.
And I want you to, maybe if you can, just draw a picture for me of what does it look like? Like, is everyone sitting in the same room and there's a mediator sitting at the head of the table? Or what physically happens in these mediations?
Well, having seen some of your court programs, Neel, we have replicated what you have in the US. In some of your court programs, the court centers have private rooms. We have waiting rooms in the Bangalore Mediation Center. The children have play areas so that when they come in for their matrimonial disputes, the children have a space to play in. So it's a typical mediation environment where they have time, space for confidential information. They have joint sessions. So it's like any other that you would find in any part of the world. More numbers, as I said, we have so many people there. It's Sometimes a little crowded, but sometimes not.
I'm going to ask you one more question, and then I'm going to be moving back to Jeff in just a moment. But Laila, most of the mediations that you started doing were matrimonial, but then you started doing more commercial mediations. How did the skills translate from mediating matrimonial cases, which are a very specific type of law and specific set of issues, to the commercial cases?
Neel, let me be honest. When I became a mediator, I was about 25 years in practice. I had never done matrimonial disputes. And I think within a couple of months, I felt I was very comfortable doing matrimonial disputes. And then when I transitioned into my private mediation space, I came with all my process expertise. I knew how to handle emotions, to understand facts, to maintain confidentiality, to connect with parties, to work with parties, to create different options and persuade them to come to a settlement, all the time keeping the peace and the calm in the room. So I was familiar with that. And I used the same process for all my commercial disputes. So today, honestly, what the subject is doesn't overwhelm me. I feel it's the same process. I have the skills to get information, to understand, the curiosity to learn. It's kind of the same thing. So I'm not confused by a different domain. I've done all the different kinds of cases, not all, but different kinds of cases.
Well, I want to turn it over to Jeff now. Jeff, one of the things we've heard a lot in India, at least when I've gone out there, is IP lawyers get nervous about not having an IP specialist as a mediator. They're worried they won't understand the issues or the technologies. I guess I have two questions for you. One, are you an IP specialist? And if you weren't when you started doing IP mediations, what are your thoughts about that point?
Neel, thanks for giving me the opportunity to talk about IP specialization. I do a lot of intellectual property cases. I'm not an engineer. I'm not a scientist. I'm not a chemist. I tell people this right up front. And then the question is, am I an IP specialist or expert? Well, compared to what or compared to who is really the relevant question. Is your judge an engineer? Is your judge a chemist? Is your judge a scientist? Almost certainly not. What if you're going to be trying the case to a jury? Do you think you're going to get a jury of people who majored in electrical engineering and computer science? Doubtful. The people who serve on juries, some have university degrees, many don't. And among those who do have university degrees, very few of them are going to be in anything scientific or engineering related, much less the particular subject of your case. So compared to your judge, and certainly compared to your jury, the mediators generally know a heck of a lot about patent law. The essence of patent law or any other field of law can be mastered by mediators who are good lawyers and are willing to work at it. Neel, you may have heard the little joke, what's the difference between a novice and an expert in any area of law? You know the answer? 48 hours. When we get good briefs from lawyers like you and Bijal, then we're up to speed because you are explaining to us exactly what we need to know, and then we know it. And what is the most important law for a mediator to know? Here's my view and why I think Laila's right when she says that mediators can be versatile and go to different subject areas. Clients come in with a certain set of beliefs. We're right, they're wrong, we're going to kill them, they're never going to get a dime from us, or they're going to have to pay us millions of dollars, whatever it happens to be. Their lawyers are telling them, well, you may believe those facts, but there's still no guarantee that the court system is going to reward you for those beliefs. What explains the gap between a client's beliefs and the fact that they may lose at trial? What explains that more than anything else are the laws of procedure and evidence, that there are certain kinds of procedures you must have in court. There are certain rules relating to the admissibility of evidence. particularly expert evidence in the intellectual property space. How many cases have there been, Neel, where a killer expert simply was not allowed to testify at all or was able to testify only on more limited grounds? Well, if a mediator understands the rules of procedure and evidence, then a mediator can help a lawyer. Remember, mediators are always working. There's a three-person team there: the client, the lawyer, the mediator. If the mediator understands civil procedure and evidence, those are the lenses through which reality is going to be filtered as it goes through the legal system. And that explains the gap between the client's belief and the possible set of outcomes. Those are the most important things. Learning patent law, learning copyright law. Mediators don't have to learn the whole field of law to mediate your case. We have to understand the tiny little wedge of substantive law that applies to your case. And then we know evidence and procedure. Almost always, we're going to be able to help you.
Bijal, do you typically seek out IP specialists, or do you look for maybe a different portfolio of skills when you're looking for good mediators?
So here in the US, for some reason, and I can't really figure out why, people are scared of IP cases. Like Jeff, I'm not an engineer. I've never been told by somebody that I can't work on an IP case. And I agree wholeheartedly that you need really someone who's passionate about learning the law and presenting the facts of the law in the best and most efficient way possible. That said, if I can find someone who has a track record of at least working on IP cases, irrespective of their technological background, I will look for that in the mediator, because it just makes the process go that much faster. You're not starting from scratch. You can refer to things such as you know, in California, we have these disclosure requirements. As you know, in Texas, we have these requirements for early disclosures, for example, on damages. So by having someone with some sense of IP cases, you're that much better off, and you reduce the likelihood that you won't have a successful result. Is it imperative? Absolutely not. I agree wholeheartedly with Jeff that really you want someone who's really in it to win it and to help both parties come to some sort of negotiated resolution, but it's not a requirement. The other thing that I look for in all of my mediators is someone who really wants to take the time to get to know the case. So in the United States, we do this early. We can have pre-mediation phone calls before the mediation. So I will do those phone calls when I'm looking at evaluating mediators, and I'll do those phone calls sometimes with my clients on the phone, sometimes without them on the phone, and ask them, what's your process for the mediation? If they say, submit the briefs, we'll just show up at your office, then I know they're not really taking it as seriously as I would want, right? I would want someone to take the briefs. I would want someone to have some pre-mediation sessions, both jointly and with each client alone. So in my mind, you really need to find someone who understands the subject matter and who wants to put forth the time to make it as successful and productive as possible.
Neel, Bijal is right. And let me add another layer to it to show why he's right. Bijal is right because one of the critical things a mediator has to do is to get on wavelength with the participants in the mediation, as Laila was saying earlier. And somebody could have fancy degrees from fancy universities. Somebody could have been a great trial lawyer or a great judge. But the question is not, were they good at their last job? The question is, are they good at this job? And even people who may be very good mediators may, for whatever reason, have difficulty getting on wavelength with you or with your particular client in your particular case. One of the reasons that I gravitated toward intellectual property law is I like the men and women who practice intellectual property law. I get along well.
Well, Neel and I are quite special, so
and handsome.
Yes, exactly.
Intellectual property law tends to attract pretty brainy, serious people. And I've got kind of a nerdy streak, and I get along well with intellectual, brainy, serious people. So I gravitated towards IP law. But even so, you may have a client in a particular case, and you might say, in this case, this client is going to love Jeff. Or in this case, this client is he's just going to think Jeff's sense of humor is too corny. We're going to go with Laila in this case, because Layla's going to get along better with this particular client for could be 100 different reasons. But without talking to the mediators and getting a sense of our personalities and our styles, you're not going to be able to make the best decision as to who is the right mediator for your case. You got to talk to us.
Yeah, and just to add one thing to these concepts, and these are all terrific concepts that I think you've added. One of the big differences between mediation and court proceedings is when you go to court and you're talking to a judge, in whether it's in the Karnataka High Court or in the United States Federal District Court, talk to the court. You don't talk to your learned friend who's standing next to you. You're not allowed to do that. You talk to the court about the things that you want, and the judge says you're going to do this, you're going to do that. And in lawsuits, often the two sides are unwilling to talk to each other in the courthouse or in the courtroom, if they're even there. Mediation tries to deal with that difficulty of emotion of people not wanting to talk to each other and put someone in between to get a conversation going where they weren't necessarily willing to do that. Bijal, in your intellectual property cases, what percentage of them would you say go to mediation?
100% of the cases go to mediation, as you know as well, Neel, being in the same field. Every case will go to mediation. It's just really part of our strategy. And in my mind, one concept that we would like those litigants in India to understand is going to mediation is free discovery for me. It is a free opportunity to hear what the other side's positions are. And so when people look at me and they say, I can't believe that the court is requiring mediation, as they do in many places, for example, in California and Texas and in Delaware, I say to myself, this is an opportunity for us to learn our strengths, our weaknesses, and to flesh them out. And if you come into a mediation session with the attitude that this is a complete waste of time, well, it will be a complete waste of time. If you come to the session with the expectation that this is a facilitated business negotiation, we are not going to resolve the case today, but it's one step on that journey. And along the way, not only am I walking to the end of this journey, but I'm also gaining some knowledge along the way. And that's what most litigants forget.
That raises an important point, Bijal, because at some of my interactions in the Indian court system, there's been a suggestion that mediators should only get paid if the mediation is successful. And before I ask Jeff and Laila, I'm going to ask you what your point of view is.
I will tell you that I have the greatest respect for the Indian judiciary. My great-grandparents were part of that a long time ago, hence my last name. But I will tell you that I would respectfully disagree. A mediator should be paid irrespective of what the outcome is. Otherwise, the incentives aren't there to at least have some nuggets of information that have been exchanged that the parties can go back to their offices, discuss, and hopefully in the future lead to a resolution.
Laila and Jeff, any additional thoughts on that point?
Neel, it's not in every court that they get paid only if there's a settlement. It's only in some courts and in some states. And that happened because, again, there's no understanding of what mediation is. The judges who administer the program have not really understood the benefits of mediation. But where they have been guided properly, like in our Bangalore Mediation Center, we had the ISDLS from the US who came to set up the program, and therefore we were guided right. Everybody who mediates gets paid. So this is a concept that came due to ignorance, and we are working towards that. But I totally agree with Bijal. The work that a mediator puts in for a failed mediation, at least in my case, is more than what I do for a settled case.
Neel, that kind of compensation scheme really guarantees that very few cases will settle. Let's say, hypothetically, I'm the mediator and you represent one side, Neel, and Bijal represents the other side. You know that I don't get paid unless the case settles. What is the incentive for your behavior? The incentive is for you to fold your arms and say, we are not paying anything. You go tell that bad person, Bijal, he's got to make all the concessions.
He says that to me all the time. Don't worry about that.
But this time he would have even a better reason to do it, Bijal, because he would be trying to put pressure on me, to put pressure on you, in order so that I can get paid. And you have equal and opposite incentive to fold your arms and to say, Jeff, we are not making any concessions at all. If you want to get paid in this case, you go tell that so-and-so Neel that he has to make all the concessions. And so when you create a series of incentives for people to be stubborn and not to make concessions in order to put pressure on a mediator to get the other people to make concessions, you're going to have a lot of mediations where there are no settlements. And indeed, you're going to have a lot of mediations that are very short and very frustrating and very unsatisfying.
I couldn't agree with Jeff more. And I also hope that our clients here in the US for Neel and myself don't also hear or come up with such weird, perverse incentives, i.e. you can only work on this case if you win it. That really wouldn't be the way that a lawyer would work, right? So why would you expect that from the mediator?
Well, that was the next thing I was going to ask you, Laila. At least for some period of time, litigators in the Indian court system get paid based upon court appearances, and would not necessarily get paid if they were going to be going to do things like mediations. Has that changed at all, or how do people deal with that issue?
Well, these are things that we are working with. It's not changed. It's still per court appearance. So lawyers resist mediation, and we have to really convince the parties and the lawyers to come in for mediation. But slowly, I'm beginning to see the change. At least there are conversations, discussions on how do lawyers structure their fees. And I'm hopeful that sooner or later, lawyers are going to see mediation as a very important part of their dispute resolution toolbox, and they're going to provide for mediation as a well-paying dispute resolution mechanism.
I want to turn back now to some IP-specific issues. Bijal, when you're working with an IP plaintiff or defendant in a case, before people are going to mediation, are there any core things you want them to think about as they're going into it? Maybe particular questions that you ask them, or ways that you kind of set up things for the mediation?
Yes, absolutely. In the United States, there are probably a couple of fundamental buckets of information that we'd like to have the parties exchange. And so I'll limit my discussion mostly in the patent context, but the same could hold true in the trademark or copyright or trade dress context. And Neel, you should feel free to chime in. You're more of an expert than I am in many of these categories. But with respect to patent cases, I like to see that the parties have exchanged information about the patent, whether the patent has been infringed, and whether the defendant has any arguments that the patent is invalid, perhaps it's not enforceable, and then some sense of what the damages are, what's the sales volume, or is there an argument against damages for a variety of reasons, such as estoppel or extraterritoriality or the like. So I'd like to see that those components are there. Now, when I serve as a mediator, I'll have those initial phone calls and I put in a lot of time at the beginning. In some situations, sometimes the facts are so clear that you need not have all those buckets and you can still have a meaningful business solution. For example, maybe it's before the product has even been launched, right? Maybe it's while the parties are still addressing how the product will actually look when it's released to the public. So in 99% of the cases, I like to see some buckets of information exchanged. There are the occasional one-offs where perhaps just the beginning of the case is the perfect time for mediation. So it's really fact dependent. It's not a one size fits all, but I'm guided by the principle that 99.9% of patent cases settle, right? And so if you go into it with that, then you're going to be a much better negotiator, a much better mediator, and a much better willing participant in the process.
Jeff, as a mediator of IP disputes, what kinds of information, not about who's going to win and who's going to lose, but what kinds of things are you looking for to help you kind of serve in your role on trying to broker a peace treaty?
Neil, there are a few things that are important for the mediator to know, some of which we can get in writing, and some of which we can only get in those telephone calls that Bijal is describing that are so critical. In a mediation brief, you can tell us essentially what is this case about. This is a case where somebody claims patent infringement against somebody else, and somebody else is defending on the grounds that the patent is invalid, or that there are no damages, or whatever it happens to be. What is the case fundamentally about? You can also tell us in writing about the procedural status of the case. Has there been a claims construction hearing? Have there been summary judgment motions filed? Has there been a lot of discovery? Are you close to trial, far from trial? Where does this case stand procedurally? And then the third thing you can tell us in writing is, what is the history of settlement negotiations? Have there been other mediations before? Have there been settlement offers and demands before? Hopefully people can agree on what offers and demands have been made in the past. Sometimes people can't even agree on that. And then in the telephone calls that Bijal is describing, wow, those have become so important as part of the preparation for the mediation. Because in every case, there's more to the story. There's personality issues, there's people issues. Who's not getting along with who? Who's having trouble communicating with who? Who's a hothead? Who's got what kind of personality? Is a lawyer having difficulty communicating with their own client? That's one of the great secrets of mediation, that the mediator is the only person with both the interest and the ability to help lawyers restore damaged relationships with their own clients. If a client should, for example, have unrealistic expectations about how a case is turning out. So I like to ask people in those phone calls, what are the challenges that we face? What are your expectations of me as the mediator? Because that can differ from case to case. And to learn about the personalities of the parties involved. Then I also like to have a discussion with the lawyers on mediation process issues. Should we have a joint session? Should we not have a joint session? If we have a joint session, what should be on the agenda for the joint session? What should we be sure to stay away from in the joint session? You know, there's some hot button issues like willfulness and intent that really have a moral component to them. And to say in a joint session, not only did you infringe my patent, but you did so intentionally and fraudulently, and you defrauded the patent office, and you're a bad person. Those are things we should stay away from in a joint session if we at all can stay away from them. On the other hand, some things like, what is the measure of damages? What is the smallest saleable patent practicing unit? Is it this or is it that? And what is a reasonable royalty rate? Well, those sorts of things don't really implicate the morality of people's conduct. Those are matters of business and economics, kind of detached from personalities. And we can often have more clinical, cool-headed discussions of issues like that in a joint session. So that's part of what we do in these phone calls as well, figuring out what's really keeping people apart, and are those things we can productively discuss directly with each other.
Thanks, Jeff. You know, it's interesting because even when we talk about IP specific things, they really seem very similar to things you deal with in almost any kind of a case. Just to add to your 2 points, I always walk in to mediations with 3 questions. The first one is asking the client, what do they perceive as the obstacles to resolution? What was the situation that brought them into the courtroom, and what's the obstacle to resolution? They may be right, they may be wrong, but understanding that is an important point. The second is what are the 5 most important pain points on how this case does or does not affect their business? And sometimes that can provide unexpected pathways to resolution. And then the final one is asking them, other than winning the case and being showered with money or being showered with not having to pay money, what do you want to get out of the case? Like, how do you define an outcome that's successful beyond just dollars and cents? And if it is only dollars and cents, what does the risk profile of that look like? Laila, I'm going to turn it to you now. We've talked a lot about how we set up a mediation, but I want to talk to you about timing. How do you figure out when's the right time to decide to go and mediate yourself?
When the parties are ready to negotiate, when they have adequate information, when they're beginning to have a mindset of, okay, let's try and understand, because they see mediation as an opportunity for private discussions, maybe as an opportunity where they will have facilitated discussions amongst themselves. So when that mindset is beginning to happen, that's a good time. And of course, we do have to, again, in India, things are so new. There's so much of lack of awareness. We have to test the parties with, give them information and then understand, are they there? But tell them what mediation is, and then slowly bring them to that state. So for us, it's not such a typical, are they ready for mediation? When is the right time? For us, it's a lot about working with them first to make them understand what mediation is, and then assessing, is this the right time? Sometimes it's clearly not the right time, then we keep off. But if there is scope, if they are willing to open to understand what mediation is, then slowly move them there. Sometimes right at the beginning, when recently I did a family business mediation, they they didn't want lawyers, they wanted absolute privacy. So that was right at the beginning when communication broke down. That was the right time. But in some others, they want to have a fight and then they get tired and then they're ready to come in for mediation. So I think it varies in each situation.
Neel, Laila is absolutely right. The right time to mediate has much more to do with the emotional state of the parties than it does with the factual state of the record. Then the question becomes, who should decide when is the right time to mediate? The people with the best understanding of the emotional state of the parties are the parties themselves and their lawyers. Who generally has zero information about the emotional state of the parties? The judge. And so there must be a question asked. And in India, you have the opportunity not to go down the path that we often have in the United States, where judges are deciding when people should mediate. Mediation is alternative dispute resolution. And judges should not be ordering people, at least people with the kind of experience and seasoning of Neel and Bijal. For lawyers with any experience with mediation, judges should leave their hands off. I do agree that when mediation is brand new in a particular jurisdiction, at that point, judges may have to force people into mediation for a relatively short while until they figure out that mediation's okay. Mediators are pretty good people. We're not out, we don't bite, we're not going to harm people. But once lawyers get the clue that mediation is okay, at that point, judges should allow the parties and the lawyers themselves to determine when is the right time to mediate.
I want to ask Bijal a question, and then we're going to kind of come around the home stretch, and I'm going to turn it back to an IP time. Bijal, you have a lot of very high-powered clients. What role does ego play on raising the issue of do you want to go to mediation or not?
I would say that egos typically are a major factor in addressing how to prepare for and how to conduct a successful mediation. The egos are always going to be there, irrespective of who the client is or who the person is. There's always going to be a feeling of right and wrong. But Neel, just to narrow down your question a bit more, what I found successful as a mediator is the fact, as Jeff correctly points out, that the opportunity to be heard is really important. And it doesn't matter if you're a Fortune 100 company, it doesn't matter if you're a Fortune 50 company, it doesn't matter if you're a Fortune 10 company, as you well know from the cases that you've worked on. There are a number of situations where the other side just wants to have a dialogue with the other party. And until that happens, they have a mental block against trying to resolve it. So we end up spending money and spending time and spending resources on litigation that could be directed towards the business. It's really amazing because Neel, I take your earlier comment to heart, where at the end of a trial, you only have one person who feels that the process was fair. And despite the fact that we know this, people choose the litigation route over the mediation route, which makes no sense, right? And so it has to be largely based upon or predicated upon the fact that egos are playing a major role in the process.
And a difference of opinion on what the risks are.
Absolutely.
So, Neel, if I may ask a question. Before mediation existed, I graduated from law school in 1980. And in 1980, mediation did not exist. And yet people still settled cases. So ego would also be involved in saying, Neel, why don't you call Bijal? Or Bijal, why don't you call Neel? And just have a regular go have lunch at a restaurant and talk about settling the case. There's ego involved in that as well, having your lawyer initiate that call. And yet those calls took place by the thousands, by the hundreds of thousands, before mediation even existed. So the idea that that ego should stand in the way of initiating mediation, well, again, compared to what? Compared to the ego not getting in the way of initiating an unfacilitated conversation regarding settlement. So mature business people, confident business people, will allow their lawyers to initiate these conversations, whether it's for an unfacilitated, let's have lunch and talk about it, or a facilitated, let's sit down with a mediator and talk about it.
Add one other point to what Jeff said, and Laila, you're probably the expert on this for sure. What I find with Indian clients, in addition to ego, is there are so many other atmospherics that come into play, right? What language do you speak? What religion are you? Etc. And those types of things. So there's this whole other layer on top of the litigation positions, the ego, the money, the impartiality, the confidentiality that come into play with Indian clients in an Indian mediation. So it'd be interesting to hear your views if we have time at the end of this.
I just want to go back to Jeff when you said, the judges should not be putting any pressure on the parties to go in for mediation. But Jeff, we need a critical mass of satisfied users of mediation. They have very little information. Lawyers get paid by the appearance. There's so much of hurt, ego, and as Bijal said, layers of other complexities. We do need a judge to put some pressure on the parties to start with. I had a case, it was in the core program, pressure on the parties to come in for mediation. They come in, the two companies come in, at the end of the mediation, they both said, why should not every commercial dispute be resolved like this? But it needed the judge to be a catalyst. So right now, I think it would help if the judges also try and persuade parties. Of course, they need to know how to do it. They need to be trained on how to refer a case for mediation. That's my take on that. And yes, in the Indian parties, there are these, there might be a third person who you would never imagine as being a great influencer in the mediation. So when I set up my mediation, the pre-mediation conference, another thing that I'm constantly looking out for is there anybody else who's influencing this resolution? So to add to all that you suggested earlier, in a pre-mediation situation, I'm also learning what are their preferences, who are the influencers. So these aspects come in very much for the mediation in India.
So with that, we're just about out of time. I'm going to conclude with one thought, because we talked a lot about what do you do before you get into mediation, what do you do during a mediation, but let's talk about how it ends. If you're successful enough to have terms that people can agree upon, it is very important for people to actually write it out as simple as possible, to say that the agreement is final, binding, and enforceable, and to actually have people sign that they agree that these are the final terms unless the parties agree to something different. If it's not always possible in every mediation, but if you can do that in the meeting room, it often can prevent further disputes down the road. And with that, I want to thank Laila, Bijal, and Jeff for joining me today. It was a great, interesting conversation. I feel very lucky to have heard all the things you had to talk about, and I feel like I learned a lot. So thank you.